The central theme at IPBC Global 2016 here in Barcelona has been the shambles of the US patent market. And our next guest says that the only way the market can recover is if lawmakers stop tinkering with it. So now it seems that the legislation that was put in place and the Supreme Court rulings and so on have kind of overshot. And it seems that Pendulum, if you subscribe to the theory, is starting to come back. Do we now need more reform in order to bring it back on an even keel, as Boris was saying yesterday morning in the panel discussion?
It's hard for me to say we need more reform. It really is. One thing I think we do need is certainly in terms of the case law. I think to a certain extent cases have been misinterpreted and misapplied. I believe that a lot of attorneys would say that eBay has been more broadly applied than it should have, and inappropriately applied. So we do have some things in place, and I feel if the actors within that framework truly held to interpreting the law, applying the rules and standards, that we probably have a system that is workable. So it's hard for me to say that any more reform is going to fix it.
Earlier today you used the word tinkering. Is that what further reform would amount to, do you think?
I think so. The AIA is really still in its infancy. But now you have desires to have follow-on patent reform, and we have yet to see how the AIA has really impacted things in a real way. For example, we do have these, proceedings in the PTAB. Now, there are those who will say that the PTAB, has gone too far in terms of invalidation and some of its actions, and maybe it has. But one thing it has clearly done is achieve one of the goals of the AIA, which was to reduce litigation and reduce the cost of resolution. Now, you can say that the PTAB judges are behaving and are taking that a little too far, but the idea that that process is having an effect that was desired, I think we should let it play out a little longer and see what happens overall. I also think that about the case law.
Even David Kapos, who was behind the AIA, says that there might be some tactical modifications needed. But he's also concerned now that we don't need the HR 9, the Patent Act, as he says. We don't need wholesale rewriting of the laws. We just need some tactical modifications. Those were his words. Would you concur, or would you also say that that would amount to tinkering?
I think there are some things about the AIA that have been some unintended consequences that we probably do need to address. And I think that that's what David Kapos was focusing on. But we don't need additional wholesale reforms that are reaching into other aspects of enforcement and litigation management. We have a lot more now from the Judicial Conference and the judges who are taking a lot more activist role in managing their cases. And to me, they're the best ones to manage discovery and behaviors of parties. We've had a lot of court rulings that have done things around fee shifting and obviousness and lots of other things that folks are concerned about. And so many of the things that would potentially be addressed by additional litigation reform have already been addressed, I think, by the case law.
Finally, then turning to Europe, and it seems that they're doing everything right at the moment, save for Brexit possibility, save for the fact that we don't actually know, because you made this point on the panel this morning as well, we don't have that case study background yet to the unified patent system, patent court, where regional and local differences were going to be ironed out. I think those were your points this morning. So what do you see as possibly derailing this seemingly golden future that everybody's talking about for Europe?
Well, it's interesting. I think that part of what might derail it is people thinking of it as a golden future, right, in some respects, instead of recognizing that it is probably, certainly as structured and as envisioned, it has a lot of attributes, but it will also have downside. We'll have bumps and lumps along the way as laws are harmonized. I think there will be, in some respect, some trepidation about the first entity that goes to the UPC, right? I think we're more comfortable with the UP because it really is an extension of the existing examination procedures in the European Patent Office. It really more comes down to whether you want to have one patent that can rise or fall in one proceeding, or if you want to have many patents across the different signatories. And many validates as we have today, where you have the opportunity to go into different jurisdictions that may have different regional laws and enforce your patents. So, I think we ought to remain hopeful. I think there's a lot of opportunity, but we ought to be cautious. And just like the AIA had unintended consequences, we can expect the UPC to have unintended consequences as well.
Do you have any red flags in mind that might be those unintended consequences?
I really don't. But I do think it will come down to the implementation by the judges of the various local courts, in particular, of the different local flavor, as they call it, that will be applied by the court, and harmonizing those and really making that effort. But if that becomes one of the goals, and the judges are highly qualified, I think it will occur. But we're going to have a bit of a transition, and people should be tolerant of the transition period.